Good afternoon and welcome to the Health and Government Operations Committee. We will be having bill hearings this afternoon on Senate bills. Please do not forward the Zoom link for hearings. Staff will not allow anyone who is not invited to testify into the hearing. I ask you to encourage people to watch the hearings on YouTube. In terms of the testimony timing, the bill sponsor or designee is allotted 5 minutes to present the bill. Up to 5 witnesses will then each be given 2 minutes to speak in support. Please stay in the hearing room until the delegates have had an opportunity to ask questions. Next, 5 witnesses will be allowed to speak, or up to 5 witnesses will be allowed to speak for 2 minutes in opposition and then respond to questions. Please conclude.
Delegate Cullison, I think it's only 1 witness on each side today. Okay. I think that's what we're doing for bills that have come over. I apologize for the confusion caused by me.
Well, thank you for that clarification. I'd ask that speakers to conclude their remarks when the timer finishes, and members must remain present with your video cameras on during the entirety of the meeting. And I'd remind members only 1 question of 1 witness. And if you have other questions, follow up offline. With that, we will begin with the first bill of the day, which is Senate Bill 125. And it is brought to us at the request, by request from the Chair of Education, Health, and Environmental Affairs Committee. The bill is State Board of Chiropractor Examiners Sunset Extension. And on behalf of the Maryland Board of Chiropractic Examiners, we have Paul Abash, who will present the bill to us. Mr. Abash, there he is.
I just had to unmute myself, sorry.
That's okay.
Good afternoon, members of the committee, and good afternoon, Madam Chairperson. I appreciate your time to allow me to speak on this. My comments will be brief. The Board of Chiropractic Examiners fully supports Senate Bill 125. To date, the Board of Chiropractic Examiners has no outstanding deficiencies to correct, and the passing of this bill will ensure that the continuation of the board's mandated responsibilities of protecting the citizens of Maryland through its credentialing, examination, licensing, and disciplinary process for chiropractors. I thank you for allowing me to present this testimony in support of the bill, and I'm available if any member of the committee has any questions.
Okay. And Melissa, is Heather Scheck in?
Yeah, she's here.
Heather, do you have anything to add or?
Thank you, Delegate. I would just say, for the record, I'm Heather Scheck, Director of Governmental Affairs at the Department of Health. As Mr. Bosch stated, this extends the board's statutory and regulatory authority for 10 years, so until July 1st of 2032. The most recent sunset evaluation from DLS is from 2009. There were no reported issues, and there is no fiscal impact on this bill. So we would, the department would request a favorable report. Thank you.
Okay. Thank you, Heather. Delegate Shalega has a question.
Thank you, Madam Chair. And Dr. Abash, it's been a long time.
Madam Delegate. It's been a while. How are you?
Good. So there was no opposition to this bill, was there?
Not that I know of.
Okay, I just had to ask a question because technically I'm supposed to do that, but I just wanted to say, hi, my back's been healthy and that's why I haven't seen you in a while.
Well, I'm thrilled to hear it.
Thank you. Any further questions from the committee or compliments to the good doctor? Delegate Krebs.
No, I just want to mention there is opposition to the bill, and I'm not at all opposed to the bill. But it just, if you look in your folder from the Secular Maryland, basically saying that chiropractic is classed with mainstream medicine. And those of you who've ever been to a chiropractor know that that's a bunch of bull. But it just shows you that people have different opinions as we look at other bills that are a little bit different. I certainly know that my constituents would never want to get rid of chiropractic medicine, but there was a letter of opposition from somebody that still thinks that chiropractors, a group, are out of the mainstream, but I would argue that they're not. But I just wanted to make that point.
Thank you, Delegate. With that, I'm going to conclude the bill hearing on Senate Bill 125, and we'll move to the next bill, which is Senate Bill 247, and that's State Board of Podiatric Medical Examiners Sunset Extension. And on behalf of the board, Yvonne Umazurek will be speaking. Yvonne?
Hi, yes, this is Yvonne. How are you?
Good, thank you.
Good. Hello, everyone. My name is Dr. Yvonne Umezurike. I am the president of the State Board of Podiatry. The board supports Senate Bill 247. The board has no outstanding deficiencies to correct, and the passing of this bill will ensure the continuation of the board's mandated responsibilities of protecting the citizens of Maryland through its credentialing, examination, licensing, and disciplinary process for podiatrists. Additionally, during the recent boards and commissions audit by the Department of Legislative Services, the board was not identified as having any deficiencies. Thank you so much for considering this testimony. The Board of Podiatric Medical Examiners is respectfully requesting a favorable report on SB 247.
Thank you. Heather, anything to add? Heather Scheck.
Thank you. Heather Scheck, Department of Health, Director of Governmental Affairs. Again, I would just say ditto to Senate Bill 125. This is another sunset bill, departmental, that extends the Board of Podiatric Medical Examiners statutory and regulatory authority for another 10 years until July 1st, 2032. And this bill also has no fiscal impact. And so the department would request a favorable report. Thank you.
Thank you. Are there any questions for this panel? Okay, seeing none, thank you very much. This concludes the hearing on Senate Bill 247. We will move to Senate Bill 132, which is the inspection of public records, notaries public, disclosure of home address and phone number. And is Mr. Wobensmith with us? Well, Melissa, did he make it yet?
So the secretary is not, but 2 members from his office are here.
Okay, so then we'll go ahead with Kathy Smith from the Office of the Secretary of State. Is Kathy here? I see Kathy's name, but all right. Then let's go to Michael Schlein. Michael, we'll let you start until, okay.
I'm here. I'm sorry, my video wasn't cooperating at the moment.
Okay, Kathy, we'll let you go first then.
Thanks so much. Thanks so much. So, Madam Chair, Madam Vice Chair, members of the Health Government Operations Committee, my name is Kathy Smith, and I am the Assistant Secretary of State. Can you hear me?
Yes, yeah, we can hear you.
You can hear me? Okay.
Yes.
Okay. Okay. So my name is Kathy Smith, and I am the Assistant Secretary of State. I'm here to urge your support for Senate Bill 132, which removes the requirement to disclose the home address and home phone number of a notary. Our intent is to protect notaries. The Annotated Code of Maryland General Provision Article 4-332 requires that the office can.
So, Kathy, I think your audio is going in and out.
Okay. Can you hear me now?
We can.
Okay.
And then we lost you again.
Let's try it
May
now.
I suggest that you turn off your video and we will hear your audio because it doesn't take anywhere near as much bandwidth to do
Sure.
There we
audio.
go. Okay, so let's try that. No, still not working.
All right, so let me try it again.
Okay.
Do you have me now?
Yes, we have your.
Okay. So the purpose of Senate Bill 132.
Still. So Kathy, we've lost you. I am going to move to Mr. Schlein, and we'll come back to you if it begins to work. So Mr. Schlein, you want to go ahead?
Sure. So Senate Bill 132 removes the requirement to disclose the home address and home phone number of a notary public. And again, as Kathy said, the change is just to seek to protect the notary's public. We propose removing the home address and phone number requirement and replacing it with the notary's work address and work phone number as what is publicly available information, unless, of course, the notary does not provide a work phone number and work address, in which case the home phone number and address would still be public information. The point is just to protect the public interest in providing contact information for notaries, but ensuring privacy of the notaries. And this will protect the about 90,000 notaries that we have in the state of Maryland. And you know, the society's changed a lot since the Public Information Act law regarding notaries was created, and you know, much different world today. So just trying to protect those notaries public and limit that disclosure to their work address and phone number when we have it. We're just trying to be proactive on this legislation and avoid any potential harm to our notaries.
Okay. Thank you. Kathy, do you have anything to add to Mr. Schlein's remarks? You're on mute now, so.
No, Michael covered it sufficiently. Thank you.
Okay, thank you. Is Secretary Wilbon Smith on, Melissa?
No, he's not with us, unfortunately.
Okay, I think we probably have the information we need to make an informed decision. Are there any questions? We're going to start with Delegate Carr.
Thank you, Madam Chair. Thank you for bringing this bill. So just to clarify, you're saying that a problem has not occurred, but that you're being proactive and you want to prevent a potential problem from occurring. Is that correct?
Yes, that is correct.
Okay. Any other questions from the committee? Okay. Delegate Hill.
Thank you. Thank you, Madam Chair. Sorry about that delay in getting to the button. I don't have a witness list, so I don't know if there's someone coming up in opposition. I saw there were 12 votes in the Senate against, and I just wanted to ask if this panel could tell us, the gentleman can tell us what were the primary objections raised on the Senate side and his response to them. His response, he won't get a chance to respond. I'd like to have his response to those objections.
So maybe the Assistant Secretary might be able to help us.
Yeah, I'm not sure what the objections were, Kathy.
Okay. Okay.
So
It's not coming through.
So thank you so much. Oh. Yeah, I think there was a question about whether or not there would be sufficient access if somebody moved. And of course, by law, the notaries are required to provide updated contact information and addresses. So I believe that question had been satisfactorily addressed.
Thank you. Okay, thank you very much.
Okay. All right, well then, thank you both very much for your testimony today. And that concludes the hearing on Senate Bill 132. We'll move to Senate Bill 212, which I think will have the same panel. This is State Government Notaries Public Official Stamp of a Notary Public. And Kathy, do you want to try going first?
I'm still hearing a lot of feedback, so if I may defer
Yeah.
to Michael, that'd be
Okay.
great.
And the
Okay.
secretary has just joined us also.
Oh, great.
Mr. Secretary, welcome. Would you like to speak to Senate Bill 212?
Yes, I would. Sorry, I was over on judiciary on another bill. So sorry that I wasn't able to be here. I presume that Kathy Smith and Mike Scheim have already given some information on this.
No, we've just started 212.
Okay, great. Well, thank you very much. I appreciate it. Yeah, what I'm here today is to urge the committee to vote in favor of Senate Bill 212, which has to do with the public official stamp of a notary. And the legislation that was passed previously and became effective on October 1st included language that could require additional information to be on a notary seal, which would have meant that about 90,000 notaries would have had to come up with a new seal to do that. And the one that we worked with in the past actually had just the county, individual county is on the seal itself. So we wanted to in essence, revert back to that so that it would eliminate any confusion, and it still does the proper notarization, the proper process in doing the notarization. So it's a fairly simple issue, I think. I do have Michael Schleim and Kathy Smith are both with us today. And if you have some specific questions on that, I'll be happy to answer those. And if I can't, Michael will.
Okay. Well, then I'll ask Michael, do you have anything to add to the secretary's remarks?
Nope. Yep. This is more just about clarifying what's in the law.
Okay. Okay, I'm going to open it up then to questions from the committee. Delegate Rosenberg.
Thank you, Madam Chair. If you could let us know what must be included on the seal on this now, the stamp now, and what I assume there would be no change as a result of this bill. What's it, and then also what's in dispute or what's uncertain?
Sure, Michael, you want to address that?
Yep. So what's required on a notary seal is the notary's name, the words notary public, and the county in which the notary is commissioned. That's always been the way it has been. But when this bill went through, it added a word jurisdiction, which for notaries has always meant, and always been used to mean the county in which the notary is commissioned. But in the bill drafting, I think to clear it up, the language about county in which commission was added, but the word jurisdiction wasn't taken out. And we just want to really get that one word out and clarify the language around what's required on a notary seal, just to make sure it's absolutely clear that it's still the name, the county in which the person is commissioned, and the words notary public.
Okay, thank you.
Okay. Delegate Johnson.
Thank you, Madam Chair. I do have a question. How will this affect the stamps outside the state? I want to know the scope of the change.
So, it doesn't. Maryland notary stamp is covered under Maryland law, and if a notary is commissioned in another state, they're subject to the laws of that other state. So a notarization done under the laws of another state is legal in that state and could be accepted here. So this would not actually impact a notary that's commissioned under the laws of another state.
All right, thank you. Thank you, Madam Chair.
Delegate Krebs.
Yeah, I'm just asking, when you use the word county, does that include Baltimore City?
Yes.
So it all, okay, just make sure.
Okay.
Thank you.
Yeah.
Okay. Chairman Pendergrass, was your hand up? You're on mute, Chairman.
Thank you twice, Madam Chairman. So I'm trying to come up with the logical reason for having someone have a notary stamp and a notary that is authorized and granted by the state of Maryland who's living in another state? Why would we have that category? It seems that if they live in another state, they ought to be getting their authorization from the state in which they live and then using the telehealth business to be able to do business in this state. So I'm trying to see how it fits together with all that we've done to make telehealth, remote notaries working. This is seeming to be mixing things up for me.
Michael, are you the best?
Michael?
Yeah,
Yes.
I can feel that. So yep, remote notaries is in effect, but many of the notarizations that are done are still done in person, where two people are in the same room, identifying a signer, watching them sign. Hopefully, right now, following CDC guidelines and all that stuff for the pandemic. But the reason you have notaries, first, the law allows somebody that lives or works in Maryland to become commissioned as a notary. So you have a lot of folks that may live across state lines but work in Maryland, and their profession requires them to be a notary for whatever it is they're doing at their job, because they have to notarize in the course of business at their place of employment, which is located in Maryland, and which would require them to be a Maryland notary rather than a notary of the other state. If you're located in Maryland and you're subject to the laws of Maryland, you have to be a Maryland notary. So that's why you have somebody that may live outside of Maryland that can still get commissioned. They have to have a place of employment or practice in Maryland in order to qualify if they're not a Maryland resident.
But wouldn't you be using the address of the employee's office? Because as I recall in the bill, it talks about if you don't have a business address, then you use your home address. And this may have been the preceding bill. I can't remember which is which now. It seems if it's their office, they should be using their office address if that's in Maryland.
So we would still collect their home address. It just, the other bill is the one dealing with the home and work address. It's about disclosing to the public their home address versus their work address. We would still want to know if we're commissioning an individual, not just where they work, but where they live. The prior bill would just make it so that the information that's publicly available about that notary is only where they work versus where they live. So we would still be, commissioning the way the law is written. It's based on where you live. And if you don't live in Maryland, we're commissioning you in the county in which you do work. That's usually where you're going to commission somebody.
If the person is being commissioned at their office, I would like you to go through your records and tell us if there are people who are commissioned in another state because they work here, but are using the out-of-state only and not providing the office contact as their reason for getting the license. I think we need to sort out who's got licenses because they're supposed to have them and who may be just sort of grandfathered in and haven't cleaned things up and really shouldn't have licenses anymore because they're no longer working at that place of employment, for instance.
Yeah, I mean, I don't have those records handy. What I would say is if somebody, we can try to figure that out. If someone applied to be a notary and they do not live in Maryland, in order to move forward with the application process, they would have to provide us a work address, a place of employment in Maryland. That way we know that they have some reason to have a Maryland notary commission. If they didn't have one, they wouldn't be. Do we get it every now and then? Somebody applies, they don't live or work in Maryland. Not sure why they're applying to be a Maryland notary, but we deny those applications as they come in. And again, with the home and work address thing from the prior bill, that's just about disclosing it to the public. That's not about how they qualify. They still have to live or work in Maryland to qualify. And without living or working in Maryland, they wouldn't qualify.
So how often do they have to renew this?
Every 4 years.
And do we check to make sure they still have a Maryland address of one sort or the other?
Yes, that information is required on both a new and a renewing application. So every 4 years when they have to renew their commission, we can still verify if they live or work in Maryland.
Thank you. That's the question I didn't know to ask that I should have started with.
No problem.
Yeah.
Glad I could.
Delegate Schleicher.
Thank you. I just would like to weigh in with a little more context for the Chair Pendergrass, if that's okay. We have a lot of people that live in Pennsylvania that work in Maryland. My district goes across the PA line up by 83. And when I used to work for Congress, the State Senator Andy Harris, we processed all the notaries go through the state senators. Yes. And so we would have quite a few applications from people who lived in New York and worked in Hunt Valley or, similar something. So, they do, as you recall, I've been a notary, you have to renew it, every 4 years. So it is something that does happen for practical reasons. It'd be nice if they'd move back to Maryland, but that's a conversation for another day. Thanks.
Okay, thank you, Delegate. Seeing no other hands, that concludes the hearing on Senate Bill 212. Thank you all for your testimony today. And we will move to Senate Bill 175. This is Senator Ellis, Procurement, Performance and Payment Security Requirements and Limitations. Is Senator Ellis with us?
Yeah, he just joined.
Okay. Senator Ellis, when you are ready, you may begin. And welcome to HGO.
Okay. Thank you very much. Madam Chair, Vice Chair, and honorable members of the committee, I'm Arthur Ellis, representing Charles County, District 28 in the Senate of Maryland. I'm here before you this afternoon to present Senate Bill 175, the title of which is Procurement, Performance and Payment Securities, Requirements and Limitations. It's a pretty straightforward bill. It requires the contractors not to have to buy certain bonds for bids for contracts from the public bodies in Maryland until that contract is ratified. That means that contract is being signed and they're ready to get to work. So, the contracting process can be very cumbersome. A lot of times it will take several months for a lot of contractors to put the paperwork together to do a bid. And currently some, not all, contractors, they are faced with buying these bonds and have to pay on these bonds before that contract is actually signed. So this bill is aimed to help our contractors, our business folks in Maryland, businessmen and women, to not have additional costs imposed on them before they are ready to ratify, i.e. sign that contract and get to work. So that's pretty much that in a nutshell. As for your favorable vote on Senate Bill 175.
Thank you, Senator. I'll ask Jacob Moore to speak and then open it up for questions.
Yeah, thank you, Delegate, and good afternoon, members of the Health and Government Operations Committee. I don't usually have the pleasure of being in HGO, so this is one checked off my bucket list. For the record, my name is Jacob Moore, and I'm here on behalf of the Southern Maryland Minority Chamber of Commerce requesting a favorable report on Senate Bill 175. As a regional voice for small minority, women, and veteran-owned businesses across Southern Maryland, the Chamber is very in tune with the hardships that business owners face. The Chamber spent 7 years building a coalition of local businesses across Calvert, Charles, St. Mary's, and Southern Prince George's counties to promote development, innovation, and competition. Senator Ellis's bill is right in line with the Chamber's mission, and we feel that it protects small and Maryland-based businesses by allowing them to more fairly compete for bids at the state level. After a devastating year for so many of our businesses, We need to protect our local and family-owned companies more than ever, and the Southern Maryland Minority Chamber of Commerce respectfully requests a favorable report on Senate Bill 175.
Thank you. I see a question from Delegate Carr.
Thank you, Madam Chair. Thank you, Senator, for bringing this bill. My question has to do with the energy performance contracts. Can you elaborate on what are the provisions of the bill in relation to energy performance contracts, and also talk about what types of companies typically awarded energy performance contracts in Maryland?
Okay, I think I heard the first part of your question, but the second part, I lost audio with that. Should I answer the first part then, or you want to say it all again?
So the second part was just what companies typically are awarded energy performance contracts in Maryland?
Yeah, okay. So thank you for that question, Delegate. So this is a part of the bill, energy performance contracts, where say agency wants to upgrade facilities and work with a vendor who will come in and modify that structure, that building, and that company will get a percentage of the savings, the energy savings. And so it's very important that that savings is not articulated at the beginning of the contracting process. So energy costs, if you look at people providing heating services, have to buy whether gas or oil or any kind of fuel, those prices change continually on the spot market. So look at the price of gasoline now, right? It's going up close to $3 a gallon in a lot of parts of the country, and within the last month or so. And so the price change on the market, and it's hard for a company to say, I will provide this percent savings and make that good calculation, say 6 months at the beginning of the bid process. And so you're looking at when you get close to that contract ratification, then you will have a better sense of the inputs to that energy contract, whether it's oil or gas or whatever entails. And so you could have the second part of your question, what kind of companies would enter into a contract like this? I'm just thinking about solar companies, say, hey, if we could come and put solar panels in your parking lot or in your roof, we can save you X number of dollars. And so that would be maybe one company who might be able to do that, or a company have advanced steam technology where they can use hybrid generation of, say, steam, taking the hot air out, energy out of the air. And so, companies like that using various technologies might approach the state on any of these energy saving contracts.
Okay. Thank you, Senator. Delegate Krebs.
Thank you, Madam Chair. And I've learned something by reading the fiscal note. I didn't realize that there's 3 parts of these security, the bid, the performance, and the payment security guarantees. And the way I read your bill is that this bill just does not make you have a performance or payment guarantee. Am I correct in that? You still would have to have the bid guarantee, the bid protection?
Yes. So you were breaking up. I think your question is about the bid protection. That is not covered by this bill, because when contractors go to bid on a contract, that is mostly required so that we as a public body are not kind of wasting our time. People not just throwing these proposals in and not being able to follow through. So that's not affected by this bill. As far as when individuals or companies decide to bid on a contract, that bond that a government body might require is definitely not affected by this bill. Just on the, I'm sorry.
So now that I understand there's these 3 different levels of bids, I understand what you're trying to do. But so how would we be sure that the person that is going for the bid has the ability to follow through with the contract? I almost think of it as a mortgage pre-approval, that they don't necessarily get the mortgage yet, but they're pre-approved. How do we make sure that somebody has the ability to follow through with the contract and once they're awarded it, because it would push other people out from getting the contract? So how do we make sure that they are able to perform the contract, short of them buying a performance bond?
Yeah, and so there are several options. We go to buy a home and we have a pre-qualification. You know, you don't really have to, you're not committed, right? And with the pre-qualification. So that's one basic simple way that can be taken care of. And the contracting officers looking at the bidders, right? They have all the documents. They know about this company. They know the financial position of the companies. So that is not being hidden. All that will be there for the contracting officers to see and to know. So it's just that, you know, we just won't extract monies out of these companies while they're waiting for these contracts to be signed to be ratified.
No, I understand it much better now. I was not familiar with that. Thank you.
Okay, you're quite welcome.
Thank you. Seeing no, Delegate Bhandari.
Yeah, thank you, Madam Chair. I really like the bill in the light that current law does not specify when in the contracting process, payment or performance security must be provided. And thank you, Senator Ellis, for this great bill.
Okay, you're welcome, sir.
Chairman Pendergrass.
Thank you, Delegate. Excuse me. Thank you, Madam Chair. I'm hear you say that there's something that could be substituted instead of actually having the bond. It would be what amounted to a pre-qualification from probably a company that would do the bond. But I don't see anything about that in the bill. Did I miss that in the bill, or are there particular words that should be used if we need to put that in the bill?
Madam Chair, excellent question. And thank you for that. That is not in the bill. And it's not addressed in the bill as far as, you know, if a contractor actually might want something, like I mentioned, they would know the financial condition of that company and would have asked that company doing the bid for a particular contract. And so, I mean, I would, you know, I wouldn't say that it's not necessarily might be, that's up to your discretion if you would want to enhance the legislation in that manner.
If you would be so kind as to find us the exact language of what that would be called and how we would need to inject that, I would feel better having that in the bill. We may not need it after the subcommittee has a look at it, but I think that it should be discussed. And when it's discussed, we should know exactly what needs to be there and if it in fact exists.
Okay, yes, ma'am.
Thank you.
Thank you.
Thank you. Seeing no further hands up, thank you, Senator, for coming and bringing us this bill. Mr. Moore, thank you. And that concludes the hearing on Senate Bill 175. We will move to Senate Bill 345. This is State Government Information Technology Review of Projects and Proposals. And I'm going to call on Michael Leahy to present the bill to us. And you're on mute, Mr. Leahy.
Good afternoon, Madam Chairwoman and Vice Chair and members of the committee. I am Michael Leahy, Secretary of the Department of Information Technology, and I want to thank you for giving me the opportunity to provide this testimony. The Department of Information Technology supports Senate Bill 345. And the purpose of the bill is to increase the dollar value threshold from $100,000 to $200,000 that triggers the requirement to obtain Board of Public Works approval for resource sharing agreements and minimizes the review of such agreements. Now, the bill would also require agencies to notify the Secretary of any proposals regarding the sale, lease, exchange, or other disposition of communication sites, facilities, or frequencies. And under the current law, the state units must defer to do its oversight and approval process when considering an RSA proposal to allow private industry to use a state resource such as a state right-of-way for an information technology purpose. Now, the low threshold lengthens the review process, which delays the delivery of fiber optic infrastructure and services and more comprehensive cellular communication coverage, often disproportionately impacting citizens in rural Maryland. And private industry fiber and cellular providers provide and rely on the speed of the market, and consumers rely on that competitive marketplace for essential services. Approval of SB 345 will hasten our abilities to bolster expansion of this infrastructure and service, while also reducing the common grievance from industry that speed to market in Maryland is an obstacle. I'll also note that the Federal Communications Commission has recently implemented regulations that require these sorts of agreements be determined either operational or not being fulfilled within 60 days of receipt. And for these reasons, the Maryland Department of Information Technology respectfully requests a favorable report on Senate Bill 345. And I and Norm Farley are happy to answer any questions you may have. Thank you, Madam Chair.
Okay, thank you. Mr. Farley, do you have anything to add to the Secretary's remarks?
I'm here to back him up and assist with answering questions. Thank you.
Okay, thank you. Questions from the committee. I've got Delegate Rosenberg. Oh, Delegate, you're on mute.
How would your experience, what from your experience tell 200,000 is the proper ceiling or floor?
Okay, absolutely. Good afternoon, Delegate. The reason that number was picked is for all of our other procurements, the Board of Public Work has required us to use $200,000 as the threshold for reporting to them. So we were just trying to make it consistent. We, as I said, have found historically that these agreements have taken far more than 60 days to complete because of the oversight, and a majority of them will be under the threshold of $200,000.
Thank you.
Okay, Vice Chair Pena-Milnick.
Thank you, Chairman. Good afternoon. I have a question. I was reading the letter written testimony of the State Treasurer, Nancy Kopp, and
yes,
she gave a letter to the committee, and it actually provoked two questions for me, if I may. The first,
please.
the fiscal note says that on page 3, I'm looking at it, quote, do it indicates that the low dollar value threshold and lengthy approval process for RSAs and other similar agreements approved by BPW harm the state's ability to compete. So according to the testimony that I'm looking at submitted by the Treasurer Kopp, all items intended for the Board of Public Works agenda can be submitted until the Friday before the meeting. Can you please describe the lengthy process for BPW approval you're referring to?
Well, we are in contact with the treasurer, and she has misstated a number of facts. And although a particular item theoretically can be brought to the board either as supplemental or as a walk-on the Friday before the meeting, that process obviously is frowned upon and is not viewed as normative. And in fact, typically with these sorts of agreements, the board approval has to go in at least 3.5 to 4 weeks before the meeting where they are going to take it up. I'll also note that currently the LCP process, the legislative review, which is purely advisory, is written to take at least 60 days. and there is considerable time lost there.
But you can still submit it, right? Even though it's frowned upon, you can still submit it until that Friday, right?
Technically, absolutely.
Okay, and may I just have a follow-up, Madam Chairman?
Yes.
Okay, will the RSAs that fall under the threshold of $200,000 be made available to the public and reported to BPW in any capacity? Would the public will be able to review it and have oversight?
Yes, absolutely. Those will be reported in the procurement reports for items under the BPA threshold. And that's ongoing right now. They've started reporting them online in real time as of about a week ago, I believe.
Okay, thank you so much.
Thank you very much.
Thank you, Madam
Thank
Vice
you.
Chair. Delegate Carr.
Thank you, Madam Chair. Mr. Leahy, can you quantify the number of these proposals that would come in a typical year or other time period? Thank you.
Certainly. I'm going to rely on Mr. Farley to give us that information because his group handles them coming in specifically. Norm, could you address that?
Yes, sir. I've got some numbers from about 2014 to date. There's actually only been there's been a total of about 171 of these agreements at the whole spectrum of value from above and below 200,000. Of that, there were only 18 that were between 100,000 and 200,000. But let me caveat that there were another 54 agreements were below 100,000 that didn't go through the review. But 31 of those, the vendors artificially contracted or lowered the amount of time of the contract so they would come under the $100,000 limit. So if it had been submitted the way they wanted to do it for like a 20-year period, it would have been between the 100,000 and 200,000 zone. So that adds up to a total of 49 between 100,000 and 200,000 agreements. If that helps.
Thank you, Norm.
And I was going to say, we have, with the anticipation of a lot of 5G coming online, we think these numbers in that range is going to increase over time.
Chairman Prendergast? Unmute.
Thank you, Madam Chairman. Yes. So I'm a little puzzled. If you're going through this more rigorous process at the moment,
yes,
why would you also be submitting these in the batches of the under $200,000? Or did I misunderstand what you were saying?
At present, Madam Chair, and good to see you, the process is that the law requires us to report these and seek concurrence from the BPW at $100,000 or more. And we are requesting to align that with all other BPW procurements that are set at $200,000 for information technology. As Mr. Farley said, there are a number of small contracts that fall between the $100,000 and $200,000 range that the current time for actual processing and approval is months. And as I said, the Federal Communications Commission has recently changed their regulations to require these procurements be done in 60 days or less. So we are attempting to simplify the process for contracts that we believe would generally be approved by the Board of Public Works without taking it to them, and aligning these processes with the other thresholds that we're currently using with them, which is $200,000 for all other procurements.
I thought I heard it said, and I thought it was by you, that you were already submitting these projects in that group of things.
Between 100,000 and 200,000 we do today. Yes, we are asking to raise that threshold to only projects over $200,000.
No, reporting in a later, not asking for permission, but reporting. I heard it said that you
They
were
are
reporting
reported
now.
in the procurement reports that come out of the Office of State Procurement, and they are publicly available. We are not reporting them specifically to the Board of Public Works. We do report them for the procurement reports that are publicly distributed on a real-time basis, as I understand it, as of last week.
These reports are not submitted to the Board of Public Works?
They are to the staff, but not to the board itself unless their staff forwards it to them. They certainly have access to them, but they are forwarded to the staff.
Is that not the board? Do you submit to someone else when you're submitting something that's to the board, or do you submit it to staff?
We submit it to the secretary for the board and his procurement advisor, Gabe Knoll. So yes, it's going to the board.
Anything to the board? Why are you making a distinction?
I don't mean to make an unreasonable distinction. Everything goes through the secretary. That is correct. Whether they choose to pass it on to the board is their decision.
Thank you.
Thank you. Delegate Hill.
Thank you very much. Mr. Leahy, thank you. I was a little confused about the implications. You said that the contractors or the vendors are artificially putting in their numbers at less than 100 so they can avoid the time delay. What processes are in place, because it's not in this bill, when you go to 200 to stop them from artificially putting it at under 200 so that they won't get the scrutiny they're supposed to get either?
I believe Mr. Farley said that. Norm, could you explain why that distinction is made?
Yeah, the point I was trying to make is, like, a vendor comes in and says, I want to do X, and it turns out that I want to have a lease agreement for 20 years. And the cost comes out to $110,000. And then we go, well, now you got to go through this lengthy process. It could take 2 or 3 months. And they say, I got to get the speed of market. I can't wait that long. So instead of making an agreement for 20 years at $110,000, I'll make an agreement for 10 years at $55,000. And then now they can do their job much quicker. So when you get to the $200,000 point, I mean, if someone comes in at $220,000 for 30 years, what makes them, say, well, I'll do it for, something under 200,000 with a 20-year contract? I don't know what oversight we can do, because they're the ones asking how long they want to do the lease for. So we can't mandate to them it's got to be a 10-year, a 20-year, a 30-year. But
the other point there, Mr. Farley, is that if they do ask for a shorter term, at the end of that term, should they choose to attempt to renew the use of those facilities, they're going to have to renegotiate at the current market price.
Exactly. They have to renegotiate, or they potentially could lose their spot.
May I ask a follow-up, Madam Chair?
Quick one, sure.
Okay, just real quick. So that's a problem that needs to be resolved anyway, possibly by disqualifying them if they've underbid, because the threshold change doesn't stop that behavior, if I'm understanding you correctly.
Right.
Okay, thank you. Thank you.
Thank you, Delegate. Seeing no further hands, thank you, Mr. Secretary, Mr. Farley, for bringing us this bill. That concludes the hearing on Senate Bill 345, and we'll move to Senate Bill 353. This is Veterans Benefits and Benefits Appeals Services disclosure requirements. And we have Secretary Owings with us today. Welcome to HGO, Mr. Secretary. You are still on mute.
Am I unmuted?
You are unmuted now, sir.
Oh, fine. All right. Madam Chair, Madam Vice Chair, it's a pleasure to be with you all today. It's a very simple bill. It's one that was brought to my attention by a veteran. As you know, there are 5 pillars in the department. One of those pillars is benefits and the services end of things. This is where the veterans come to us to sign up for what they presume to be service-connected disabilities or illnesses that they got while serving. On appeals, simply put, when they're turned down by the VA or when it's deemed that what they think is wrong is not really wrong, they more oftentimes than not fall away from the department and seek counsel elsewhere. The problem with this is all 100 recognized organizations serving veterans have what's known as the service officers that also handle not only the initial sign up, but also any appeals that they may have. What happens on occasion is that a veteran will go find an attorney, and I have nothing against attorneys. That's not what this is about. This is about the veteran finding an attorney who thinks that they can do a better job than any of the 100 recognized organizations that all have certified service officers. The problem is that when the veteran signs up, they're locked in. There's nothing they can do about it once the attorney is recognized. They get anywhere from 30 to 35% of the benefit should they be successful in the appeal process. The difference is that we also do the appeal process, as do all of the service officers that work for all of the 100 organizations. So you can see where this was brought to me, as I said, by a veteran, and it cost him a little bit of money, quite a bit of money, as a matter of fact. The appeal was won, but that's not to say that we couldn't have handled the appeal had he come back to us in the first place. Very simply, this says that any attorney on appeal that accepts a veteran and is successful in that appeal process, they will disclose before going into this that there is a fee associated with what they're going to do on behalf of the veteran. Very, very simply, Madam Chair, Madam Vice Chair, members of the committee, that is the bill, and I would hope that you would see clear to pass this piece of legislation that has come over from the Senate. Thank you very much for your time.
Thank you, Mr. Secretary. Are there questions? I have a question. So currently, if the veteran hires a lawyer, there is no requirement for a contract that identifies the cost up front?
Delegate Collison, there is no requirement whatsoever that they even tell them that there'll be a fee until after the fact in a lot of cases.
Thank you. Thank you for bringing that to our attention.
Yes, indeed. Thank you all very much.
Are there any other questions from the committee? Chairman Pendergrass. Unmute.
Nice to see you, George.
Nice to see you, Madam Chair.
Or hear you anyway. Oh, there you are. You are. Yeah, I got it. So I'm a little confused. I think if I'm a lawyer, which I'm not, and I write a contract with somebody to take their case, it would be in the contract what the fees would be. And if I don't have a contract with the person, then the person doesn't owe me anything because there's no contract for that person to pay me. So how does that happen that a person has to pay something that he hasn't agreed to pay, or she?
Well, here's what happens. They automatically, a lot of these elderly veterans don't know any difference. So they will go get a lawyer, or someone will recommend a lawyer. So they'll get the lawyer. It is disclosed to them that there'll be a fee associated with it. But the problem is we and all other 100 associated organizations that represent veterans across the nation at the VA on appeal do the same thing, and we do it for free.
I understand.
So we're just asking that the lawyers let them know. I think the bill says, I don't have the bill in front of me, but I believe that the bill says they will let them know that they can also get the service free back at the department or whomever they go to.
I see. You're suggesting that they might not be mentioning that to their potential clients.
That's correct. I believe that's part of the bill. I'm not, like I said,
Thank
I don't
you.
have it in front of me.
Okay.
It's a
Thank you.
truth. I like to look at it as a truth in accomplishment bill is what I like to look at it as.
Thank you.
Thank you all.
Any other questions for the secretary? Seeing none, that completes the hearing on Senate Bill 353 and the work before us today. We will be back on the floor at 10 o'clock tomorrow morning. You all